We have a quorum of 5 members. And the item before us is a proposed zoning text amendment to amend 6-4-7, which pertains to bed and breakfast establishments. So we will proceed with a report from the committee, ad hoc subcommittee, which has been considering this, and consideration of a proposed text. Is there anything that the subcommittee wishes to bring to our attention?
Mr. Chairman, I did chair the subcommittee, and I'm prepared to make some preliminary remarks about what we've done to date. With your permission,
that would be extremely helpful.
Okay. Excuse me. Some of you may remember, some may not, but a gentleman by the name of James Pritzker, I think it was last summer, in the summer of 2011, filed an application to operate a bed and breakfast at 300 Church Street in Evanston. And I think the first step in that process, if I'm not mistaken, was an appearance before the Zoning Board of Appeals. The Zoning Board of Appeals denied Mr. Pritzker's application. From there, it went to the, it went to the City Council, and the City Council saw fit to overrule the decision of the Zoning Board of Appeals. And I think it was a 7-2 vote. I may be wrong about that, but Alderman Fisk and Wynn voted to uphold the decision of the Zoning Board of Appeals. But the majority carried the day, and Mr. Pritzker is now in the process of running a bed and breakfast at 300 Church, which is right across the street from the lagoon in Evanston. It's the foot of Church Street. In the wake of that decision, Alderman Fisk and Wynn proposed certain changes to the existing bed and breakfast ordinance. And so they appeared before the Plan Commission some months ago, and it was decided to form, the Plan Commission decided to form a subcommittee to consider the various changes that they had proposed, because there were some substantive, meaty issues to deal with, which would have been perhaps a little unwieldy before the entire Plan Commission. So it was taken up by the subcommittee which I chaired. We've met 2 times. The first time was in December, if I'm not mistaken, and we had a sort of a preliminary meeting where some of the issues were discussed. There was not a quorum at that time. We met again in January, and we did have a quorum. Both Alderman Fisk and Wynn were in attendance. And we considered the various issues that were raised and the various changes that were being proposed. And I think what emerged from that last meeting was, in most respects, a consensus on certain changes for the Plan Commission to consider. The minutes, Craig, did you prepare the minutes? It sort of outlines the areas of discussion at the subcommittee level, and it details the decisions that were made. There's about 10 items having to do with, for example, the basic definition of a bed and breakfast, ownership requirements, proximity requirements, parking requirements, the number of guest rooms that would be allowed, the number of special events that could be held, and a couple of other things. And you can see those in the meeting minutes on page 1. Down at the bottom it says bed and breakfast discussion. And there's a dozen bullet points, and we can go through those if you'd like. There was only a couple of items where there was some disagreement. One of them was parking. One of them was special events. One of them was ownership requirements, although I think we reached a full agreement on that. And then there was another issue of proximity. So we are here tonight for the Plan Commission to consider the decisions that the subcommittee made and the decisions that they did not make, and perhaps to wrap this whole thing up, and then we can send it on to the council. So I suppose for now, Mr. Chairman, that's sort of an overview of where we've been and how we got here. If you would like, I suppose I could go down these various these points that were discussed.
I think I see a draft of the proposed changes. Maybe it would be easiest to go through the draft.
Okay.
But we still have issues that were not addressed, that we did not agree on.
Ken?
For the record, Ken Cox, City's Law Department. There is a copy of draft text included in tonight's packet. It starts on, I believe, looks like page 7 to me, or so of the packet. First page being 647, and then accompanying by 6483, 61612, and 61635. Commissioner Freeman is correct to point out that there was at least one issue where the subcommittee did not come to a consensus, and that's regarding the temporary use regulations for special events. The language is included here just essentially to direct the complete commission's attention to where such regulations, if it is your recommendation to create them, would go. But that those discussions during the subcommittee meeting came to a 2-2 tie. So at present, there's no recommendation to include them in any ordinance that might go before P&D and the council as a result of your recommendation.
Was there anything else that you believe there was no consensus on?
Well, I think that was the only thing that there was no consensus on, but I think there are a few issues that the board in general, I think that was the only one that was no consensus on and that we pushed off. But while we did approve, I think some of these issues, as Stuart said, do deserve some conversation among the rest of the people on the Plan Commission, the commissioners, and from my opinion, specifically around number of special events, restriction of distance between B&Bs, and perhaps even number of kitchens, but those are the three that I have issue with. Do you have issues? I think.
I thought we'd probably wind up going over them as they're listed in 647, and at that time would be appropriate to discuss it further if there's any strong feelings on anything.
The best way to proceed.
Yeah, I don't think we should be rubber stamping anything that comes out of committee without us talking about it, especially as Stuart pointed out that there were quite a few issues that didn't have consensus.
Not to worry. I've never known the Plan Commission to be a rubber stamp.
I'm not worried. I'm sorry if I offended you with that.
Not offensive at
Okay.
all. Stuart, let's run through it, through the draft, and then people can raise any issues they might have.
Okay, Ken, you want to take this, and then we can just sort of jump in as necessary.
Sure. The proposed text is underlined and struck through to indicate the changes to the existing text in the zoning ordinance. So the first part is in the title section of itself, 647. And one of the issues that was discussed at the various meetings is that the owner-operator, that whoever operates a B&B establishment should own it, operate it, and also occupy or reside therein. So the language is written to say that a B&B establishment is an owner/operator occupied single-family or two-family dwelling where short-term lodging and morning meals are provided for compensation. The next sentence is new at the request and suggestion of the two aldermen. The owner-operator occupants shall have legal or beneficial title interest in the subject property that exceeds 50%. At present, the zoning ordinance generally defines an owner as someone with any legal or equitable interest in a property, essentially, it's essentially that broad. And there's a concern that for these types of establishments, the owner should, at the very least, have some sort of majority ownership interest to ensure that their operation of the establishment is sufficiently responsible. So the language here is to make sure that they do, in fact, have at minimum a majority interest in the property.
Mr. Pritzker, for example, lives next door to 300 Church Street, and the person who will be operating the bed and breakfast has a 1% interest, and I think that's what sparked or prompted the requested change by Alderman Fisk and Wynn. So now you've got to have a majority interest before you can.
Sure.
Yeah, Ken, does that address the concern that we had, or at least I had, about having your property in trust? Is this wording do it?
I believe so, although I'm certainly not wed to the language if anyone has suggestions. But by indicating that the owner-operator occupants shall have legal or beneficial title interest in the subject property, I believe that covers things. Again, there are various permutations that we might not have foreseen, but I think that should be sufficient, unless someone has an indication to the contrary.
When I first read it, because of the slashes, I wasn't quite sure what was meant. I mean, I rarely see slashes in definitions of documents that I read or write. So my question really is it crystal clear to everybody else that you have to be all three? And if it is, that's fine. I had to read it 2 or 3 times to understand that was the intent.
No, it's not clear. Would hyphens be clearer?
I think it might be clearer if the intent is that the holders of 50% interest should be living there. I think that might be a better way to say it. Is that the intent?
If the intent is, it seems to me that they have to be a greater than 50% owner, and it could be a he, a she, or a they if it's, a couple of whatever sort. If they have to have that interest, also be the operators, and also occupy it. I think one sentence to that effect would be a better way of clarifying it. I mean,
Maybe 3 sentences.
Yeah. It's sort of a backward way of defining who it is that can own it. So I'm just suggesting a clarifying language. You got to be all three, just so that nobody tries to nitpick it otherwise and suggest that slashes mean something other than what our intention is.
I don't have an objection to that. I was just striving for succinctness, essentially.
I know, and it is
It
brief,
is succinct,
but it may not be crystal clear.
maybe the regulatory section should be not in the definition. Go ahead.
I agree that I think the definition should be teased out in a couple of sentences, but I just have the following concerns with this definition of property. So if you had if you had the second generation, you had 4 kids and one remains in the house and they each have 25%, so the kid that lives in the house could not run a bed and breakfast, which
That's right.
it is questionable to me. In my mind, that is sort of a questionable call. Second, could you possibly be the owner and an occupant in the house? And suppose you are a couple, you live with your husband, you're in your 70s and want to run a bed and breakfast, and you hire someone that comes and operates the thing for the day, so that the other person does the laundry, cleans the bedrooms. You still live there, you still own it.
And possibly you're still managing it too. Certainly,
Yeah,
I don't
but you
think
don't
this
wanna
precludes
do-
anyone from hiring staff to help them. But I think we're implying here that they have to be the decision maker in terms of operation. Was that the intent?
Yes, I believe so.
Any other comments?
To
Okay.
Patricia's point, I originally wanted to see a 30% interest to accommodate the very situation that you have described, Patricia, where you have a couple, for example, and maybe there's a brother or there's an aunt or a child that has an interest in the property but may not have a 50% interest. So if they don't, they're foreclosed according to this definition. That's why I originally wanted to see something less than 50%, perhaps at 25 or 30% interest, which is a substantial interest, but it's less than 50%. It's more than 1%, and that was the problem, at least perceived by those who opposed the Pritzker application.
Stuart, if I recall, isn't the issue more framed in the fact that you want it to be a family that's owning versus, because the conversation came up about, putting it in trust, and shouldn't it be more based on a family owning it? So a family can own it, but perhaps the son is living in the house and running it, but it's still family owned. I think isn't the issue to make it not corporate owned? We don't want corporate owned B&Bs.
Why don't we say that?
Isn't that what the big issue? The real issue is we want family ownership. We want to encourage people to be able to stay in their homes longer, own their homes longer, that have been long-term residents of the city, right? Versus somebody selling to a corporation and having the corporate-owned small hotels.
I don't think this definition forecloses the possibility of a corporation. I mean, I can see people forming a corporation if they decide to operate a bed and breakfast, to have an LLC.
That's correct. In fact, we had that conversation how, for liability, the owners should form an LLC. I'm just trying to get to the fact that I too agree with you that 51% may be too high to require for that person to, the person with 51% has to live there.
Mr. Cox, did you have a comment?
I did, but the discussion from Commissioners Freeman and Updike elucidated my point, that there was discussion as to whether or not corporate ownership should be allowed at all. But I believe that at the end of the day, the consensus was that it would make eminent sense for someone who planned to operate a B&B to create an LLC to provide a liability shield.
Now,
So we need to have an alternative for corporate ownership, with the ownership of the corporation being some percentage and the owners living in the property.
That
I mean, there's
The
nothing here
ownership
that would
interest-
suggest corporate ownership is possible.
The ownership interest in the corporation was not discussed at the subcommittee. The issue then, the idea, I believe it was either implicit or simply just not foreseen at the time, was that if you had a family that created an LLC in order to operate their B&B, that their ownership interest in the LLC would still have to reach the same percentage, if not exceed it. But that is not explicit in the text. But I believe that was the.
that was.
So we would want to add that to the text, the possibility for an LLC.
If it's the will of the commission.
Commissioners?
Yes, I think that you should be able to have an LLC, and that's the whole conversation at that subcommittee, was that in order to protect yourselves for liability, you do want to form an LLC. But I believe the implication is that the owners of the house, that 50+%, are in fact the people that are shareholders in the LLC.
So, the incorporators would be residents.
Right.
That's correct.
If we manage to solve the owner-operator-occupant problem, do we really have to address the LLC problem? Because the LLC, the incorporators, either are owner-occupants or they're not.
It doesn't say that in the text.
His point
It says
is,
it right. It says
does say
owner-operator-occupant. If
Yeah.
I incorporate
And
as an LLC, I'm an owner-operator-occupant.
No, you're the owner of the LLC.
not the owner of the property.
You're not the owner of the property,
Can be different,
and
that's right.
you're not the holder of a beneficial interest. And as I read this definition, it would not qualify. I'm just suggesting adding a sentence to make it clear. Now, it sounds like there isn't a consensus on the greater than 50% item, and that's probably the key policy question here. The other stuff is definitional. So let me ask what your opinions are as to the percentage of ownership who should be occupants of the property.
Are we going down the line?
Anyone, I'm just asking for anyone that has an opinion they wish to express, and some, what percentage are you interested in and why?
Well, as I said before, I would recommend 30%, which would allow a couple, for example, that has a sister or a brother or a child who has an interest, an ownership interest in the property, to run a bed and breakfast.
Well,
So I would say, my vote, if I had a vote, which I don't, but it would be 30%.
You've expressed your opinion, but didn't give us a percentage.
I was fine with the 1%, so I don't see a problem. I'm in laissez-faire mood tonight, so.
And the others?
I think the issue is about family ownership. So I don't have a problem with the 51% if that 51% ownership is based on the family. So it can be children, it can be sisters, it can be brothers. I don't think it can be necessarily should be cousins, but immediate family that owns the house and as determination of it. So that's my concern. That if a son
More about what a family is.
It can be any definition of family. That is, if you want to talk about husband, wife, same sex or not, and their children, I think would qualify for that. And their sisters.
Children by blood or adoption.
Yes. And I would also think the sisters, so I would also think brothers and
Grandchildren?
sisters. Yes.
And
My issue is that if you're restricting, somebody from running a B&B that's a family home, that's my
the
concern.
zoning cases are very contentious about definition of family, which is why I'm asking what you had in mind.
I'm not a legal expert on that.
No,
So,
I'm not asking for the law. I'm asking what you would like it to be.
My opinion is if my sister, if I had a brother and I had another sister, we inherited a property from our family, from our parents, and one of us wanted to take on the property to run a B&B, and everything else fit in with the ordinance, that 25% owner of the property should be able to run that B&B since he is it's a house that's in the family. That's my perspective, and that's why I think you have 100% ownership, right? Because there's the four brothers and sisters that own that property, but only the 25% is going to live there and run it, and I don't have a problem with that. So that's why I think the 51% is okay as long as it's family. I don't know how to define family.
Okay. Mr. Sure?
I actually tend to agree if the concern is the family. If you had 4 children that owned it, then you would need at least 3 to consent to do it. And maybe that's a good reason to leave it at 50%, rather than have one of the kids decide he's going to run it and the heck with the other 4. So I'd go with the over 50%, no matter how they could put it together.
It would be a family problem. It's not our problem to solve.
Right. Well, they have to resolve it before it becomes our problem. Okay.
No, we require 50. No, I'm not going to go there.
Any comments?
Yeah. Okay. I think once you start reducing it below a majority stake, you start opening the door for other issues to come up. And I think when Alderman Fisk came here, part of what they're trying to do is actually make sure that whoever owns it actually resides in that place and actually has a majority stake in it. And if you start playing down with the numbers, it becomes, it opens the door for other cooperatives to come in there. And I do understand the whole idea that you can form a corporation to basically stave off being responsible. Placing the burden on the corporation. But I think if you start playing around with the 51% stake, it becomes something else.
I agree with you.
Ken, do you have enough to craft a definition of family and amend this, probably taking the regulations out of the definition and allowing legal interest of 50%, beneficial interest, or ownership of LLC at 50%?
And provided that we're maintaining the idea that whatever combination of owner, operator, occupants have at least more than a 50% interest, then I think there is. If there's going to be a recommendation for a different percentage, I think we would need a motion and a vote.
Now, the notion of family that's suggested here is different than, I think, the zoning provision, which is one or more persons related by blood, marriage, or adoption. I guess that covers grandchildren and brothers and sisters of the owners.
Not to intrude on the commissioner's authority to debate on this, but I would caution against invoking families when working on these definitions, given the myriad possibilities of applicants for the situation. You could have, any number of people living together who are not legally related, but nevertheless operate as a household, and potentially could apply and getting into the issues of such an application and determining whether or not they met a definition of family either in 618.3 or within this ordinance itself, I think would be more trouble than it's worth.
And actually, I agree with that. When I said I agree, I wasn't referring to the family portion of the issue. I was agreeing with the 51%, or in excess of 50%. I think, you know, we can spend a lot of time thinking about all the possible permutations of ownership, but if our goal is to have the primary owners also be the operators and the occupants, I think the in excess of 50% does that for us. And however people want to set up that ownership, whether it's in an LLC or some other kind of entity, I think would be up to them. But in my opinion, the in excess of 50% for ownership who also operates and occupies seems to achieve what we're looking for here, which I think is to make the establishments somewhat non-commercial, to be more of this hybrid ideal that we've been talking about. I think family really could muck it up. And
family's a problem. I was just looking at the 4 definitions, and the 4th definition is almost any group of people.
I'll withdraw it.
So what we're really saying is that it should be occupied. The occupant, 51%, over 50% of the ownership should occupy the property.
yeah.
That's pretty simple.
I think what we're saying is what
And
we've got here.
operate and live there.
Well, we don't have that because we have owner/operator/occupants, and arguments could be made that they're in the alternative.
Well, the slash was actually supposed to go. I think that was supposed to be cleaned up. And once you cleaned it up with the 3 sentences that you recommended, I think it will get us where we need to be.
So is that? Let me ask for a vote on the greater than 50%. Who favors greater than 50%? 1, 2, 3, 4. Okay, so we have a number. And is there a consensus on wording this so it's clear that the type of ownership doesn't matter, and the percentage refers to the percentage of the ownership that should occupy the property? That's the consensus. Then let's move to the next section, which I think is cooking limitations. And Seth, you said you had some questions about this. Maybe others do too.
My issue with this also goes to the issue of number of events that we allow in a year. So I disagree with 3.
3? I'm on cooking limitations. I haven't gotten there yet.
Yeah, I understand. I'm saying the reason why I disagree with not being able to put in other kitchen facilities or other facilities is that I think a B&B should be allowed to do more than 3 special events. And generally a special event, you're going to do some cooking. And I believe that a typical home would not necessarily have a kitchen that has the capabilities to support any.
So what do you think should be the requirement with respect to cooking limitations?
Question. Should we then address first the issue of special events, then come back to the issue of kitchens?
Well, let me just ask what you're interested in for kitchens.
Well, Well,
Maybe
I don't
you
think
wanna
you should
limit-
have an industrial, necessarily we should be allowing like a restaurant-style kitchen in a garage or a basement. I feel that you may need to augment the cooking facilities.
By adding additional kitchens or changing the,
I am not an architect, I'm not an expert at this, so
I'm just
can't-
interested in your
It could
your
be
view.
both, either or. I don't know. I just feel strongly that limiting a B&B owner to 3 special events, I don't agree with that.
Well, maybe we should move to special events.
Well, we may want to go to another one that I don't agree with even more, because I would recommend to kill the whole ordinance because of this one, and that's the proximity of B&B. You know, if you're going, so my perspective, as I said at the subcommittee, is that while I understand limiting number of B&Bs in an area, and I wouldn't want my whole block to be converted to B&Bs, I don't think it's fair to say, okay, a B&B that was allowed 20 years ago could literally have that B&B license in perpetuity, and nobody else in a 2-block radius can ever open a B&B. So I don't necessarily think that's very fair to the citizens of Evanston, because that's like saying, okay, well, you've been granted something in perpetuity. And I just don't think, I don't even know if that should be something that's the city should do legally. I don't know, I'm not a lawyer, but that I object to. And I don't know how we reconcile that we don't want to have, including myself, I don't want to have my whole block I don't want to live in a place surrounded by B&Bs. But on the other hand, we're saying, okay, the first lucky guy that comes in this 2-block area can have a B&B, and then nobody else in perpetuity potentially can open one. So that's my biggest issue with this whole ordinance.
Mr. Ford?
Are there other land uses which have proximity limitations on them?
The 900-foot radius is the same distance as residential care homes.
Care homes.
And so that was the model on which the proximity restriction was crafted.
Okay, thank you.
But rooming houses, for example, where you have more than 3 unrelated persons living in a dwelling house, there are no proximity limitations for rooming houses. And yet there's no limit as to how many people can live in the place. So the adult care facility, right, is 900, but that's the only other one that I know of that has a proximity limitation.
And those are generally big structures. They're not homes, correct?
Not necessarily.
Well,
Rooming houses, I've got
No,
4
not
of them
rooming
across
house. I'm
the
talking about I'm talking about extended assisted living places.
Not necessarily there either.
Do we have any in Evanston that are actually houses?
Mm-hmm.
Yeah, Girls Hope and Boys Hope.
I'm sorry?
Girls Hope.
Okay.
That's what started all of this 15, 20 years ago.
Okay.
Distancing requirements are common for uses with cumulative impact. Yeah.
So just one thing I think that might alleviate some of Commissioner Freeman's concerns about the proximity restriction, although it's certainly up for debate whether or not there should be one, and if so, what that distance should be. You mentioned a few times that potentially an operator of a B&B, operation of a B&B could extend into perpetuity. Actually, that ties into a different part of the discussion, wherein it's actually under L here, that the special use permit for B&B, according to this draft, would attach to the permittee. It would attach to a person or persons, not to the property. So at the time, whenever the persons who at that point had the who had the license, the special use permit, were to sell, die, what have you, presumably it would cease to be. Now, there is a mention of corporate ownership. Corporations obviously can outlive people by a great deal, but
corporations are people, baby.
Depending upon whom you ask and under what circumstances. So the issue then becomes whether, I guess essentially, whether it's reasonably foreseeable that we've been shorthanding as a family-owned LLC, an LLC that's formed by the residents in order to provide a corporate shield for the operation, would persist after their demise.
I can assure you that all of the texts used to teach land use address this issue, and that tying a special use to the owner is unconstitutional. There is a way to accomplish that, I think, which would be to have some regulation on the fitness of the licensee. But I think it's not useful, and I know you reach a different conclusion on the law, it's not useful to tie a special use to the person that happens to own it.
So if it's not perpetuity, it could be 20 years, it could be 30 years, but it's still excluding basically anybody else who's living there at the time or within those 10 years from a good 10 to 20 years of being able to do the same thing. So my point is that.
The same thing happens with spacing distances for billboards, which are large in many states. It may not seem like it when you're driving 70, but there's a spacing requirement, and the larger sign companies buy these things up to exclude the smaller sign companies, and they've been upheld, but there is the fairness problem that you describe. I think it's possible to find a way of reviewing fitness of owners so that when you get a change in ownership, you can do another review. So that would limit it to some extent. Unlike corporations, we probably won't live forever. Yes.
Well, I mean, even if we do that, how do we prevent somebody from acquiring that property for the sole purpose of owning a bed and breakfast?
I think we don't under this ordinance.
Yeah, because, I mean, here's my concern. My concern is that I may want to buy that building in the block that has that comes with a bed and breakfast. And if there is nothing that, if there's nothing indicating that I cannot operate it, if there's nothing telling me that that license is attached to the particular owner that's in there, then that's what I'm going to buy, because it becomes an investment at that point. And I mean, I'm also bothered by this because we talked about it the last time we actually, when Alderman Fisk came here, and I think this whole bed and breakfast thing was actually put together to help people who at one time were struggling or can use additional income. And if it's attached to one specific building, then it deprives other people of any opportunity. And I think what we should actually, I'm just putting it out here, we should maybe say, well, when an owner leaves or an owner abandons the license, other people in the community should be able to apply to also set up something there. That way it's not only attached to that particular house.
I was going to mention, though, if we don't have a proximity requirement, we still have the fallback of the standards for a special use, so that when a fast food restaurant comes in, for example, you know, they have to show that the number of, and I'm not quoting this correctly, but that the number of special uses in that particular area doesn't adversely impact the neighborhood. So I think by virtue of the standard itself, we really have protection against a whole block
Yeah.
becoming bed and breakfast. Or it may be that in the wisdom of future commissioners or zoning board members, it makes sense for a whole block. But they have that discretion then
It
to
says
decide
that
whether the standard is met. And if they believe the standard is met, then they could permit more than one in 900 feet.
it says the cumulative impact of all the special uses.
Yeah,
Stuart?
and that's the one I was referring to, but I didn't have.
I agree
have it in front of
entirely,
me.
and that is the precise reason that I opposed any proximity limitation, because this is a special use. And the council has the last word on its impact if you have more than one in a block, for example. But Alderman Wynn and Alderman Fisk said they didn't want that. They wanted this in writing, and then if the applicant wanted to operate a bed and breakfast within a certain proximity limitation, that they could apply for a variation. So it was putting the burden on the applicant, and I don't think it belongs there. I think the council has the discretion to assess the impact of successive bed and breakfasts, if in fact there are any.
Yeah, I
Well, if the council has the discretion, then by saying that you cannot have another bed and breakfast 3 blocks from another bed and breakfast, they can also basically overrule and basically say, well, in this particular interest, it apply, right? I think the whole idea here, I think, is to prevent oversaturation of bed and breakfast in a particular neighborhood of Evanston.
I see all the lights on. Go ahead.
I just wonder, it sounds to me very reasonable, is this on? I think so, to rely on the special use limitation rather than put it in writing in here. But I'm generally a bit bothered by the whole procedure, and I think I mentioned this already once. So in this 300 Church Street, it sounds like 2 aldermen did not like the decision of their peers. So they're coming to the committee to avoid this happens to them again, which sounds a little bit questionable to me. So it really makes me unhappy that we are following what they want to subvert their own process.
Well, the good news is we make a recommendation to the whole council.
Yeah.
And so it goes in front of the council again.
bravo,
Seth?
bravo.
Yeah.
Stuart, I agree with you, and so I'm glad I'm glad I brought this up, because I think then the whole council should make the decision if there's a negative impact. And the example I used in the subcommittee meeting was I live on Wesley, and this would preclude, it's a pretty long block up to Asbury. There's some nice homes up there, so if I had a B&B, this would preclude somebody from Asbury, which is like a completely different neighborhood than Wesley, from doing it. So I think this is a good solution, and we should take this out.
Let me ask how many of the members would prefer to eliminate the distance requirement and rely on the special use provision? 1, 2, 3, 4, 5. And how many would disagree with that? 1. It looks to me like the, not consensus, but the overwhelming view is to make a recommendation not to include a distancing requirement.
But that you...
And I would ask Craig, when you write this up, to provide the rationale for that determination. And indicate that it was not a unanimous vote.
It's 6-1.
That would be true.
So say 6-1.
Indicated 6-1.
Indicate 6-1.
And you may also want to indicate that the lone dissenter wanted it stated that it makes sense to have to define as to how many feet.
Now, you wanted to talk about, before we talk about cooking, you had something different that you thought was relevant.
Yeah, it was the issue of the number of special events. So I'll give a brief overview for those who were, my issue was the number of special events. I'll give a brief overview for those members who were not at the subcommittee meeting. And the issue the aldermen and others have had is that, you know, you wouldn't want to have a B&B have a special event every weekend of the year. And you could foresee that happening. And I wouldn't like that either. But I feel that 3 is very limiting as to I just think that's very limiting to running a business that offers special events, and you know, you probably shouldn't even do them or advertise that you do them, because if you can only do 3, I really don't know what the point is. So my concern about the number of special events is if you did have more special events, you might need some augmentation to your cooking facilities, or if you don't, I guess you can just cater. That was my point.
Are there any other views on this?
The number of special events, or the cooking?
Special events. We'll follow your suggestion and do those first.
Guess not.
Is there, let me ask, how many of the commission members think that the number 3 for special events within a 12-month period is appropriate?
I agree with Seth that it's a little low. I'm not sure what the right number is. I mean, what do we want, 6? Do we want 12?
You know, the issue, if you had 12, then in the month of July, you could be living next door to a special event, 3 times a week, right? And that would be kind of too much. So if I were to make a limitation, I would maybe do it by month, not by number in a year, because if you do 6 in a year, you could have 6, all of them piled up in August, and that would be a real crappy August to live next to a house that's got a special event going on every weekend plus. So that would be my perspective on the number of special events allowed. That would have to be regulated by per month, not by the year. And I think that might get to the issue that the alderman had, is that just too many events could really ruin a neighborhood.
How are you defining a special event? I mean, what if it's held inside, they don't have a loudspeaker going, you don't know what's going on? Does that bother you?
No, not at all.
Unless you're not invited.
No, I think a special event, from my understanding of what we were talking about, was like outdoors in the backyard having a party and lots of people on premises, like, wedding parties and things like that.
Do families have a limit on the number of parties they can have?
Nope.
So why are we imposing this limit on the owner occupants? If the reason we're putting the more than 50% limit is so that they make reasonable management of their property? I don't think we need a number of special events. The reason we're putting this 50% is because we say that will ensure reasonable management of the property. Families don't have a limit on the number of parties they can throw.
Well,
let me ask, Stuart, where did the special event question come from?
Dave Reynolds is a concerned citizen.
Dave
Perhaps
Reynolds,
he can shed some light on this.
In the audience.
My name is David Reynolds. I live at 204 Davis Street.
There are limits on what you have a right to do with your house. You only can have so many filmings a year. I think you can only rent your property out for one event a year. Am I correct in that?
There's a limit, sir.
There is a limit to what an individual can rent his house out for. And one of the things that you haven't looked at is that in this industry, there are basically two levels. There's a B&B level and there's a B&B Inn level. The B&B Inn level is more generally a corporate operation. It more generally doesn't have a live-in component. It has lots of events. It may or may not be in the same zone as a B&B. What the 300 Church brought up and the type of B&B that is attempting to be dealt with here is the family-owned, single-family, two-family residential zone B&B. There is a recent history of the Historical Society renting out their yard for weddings 12 times in 12 weeks, and it was very deleterious to the neighborhood. You really have to have some limit on these events to protect the neighbors, and as long as I have an opportunity to speak, I do think that you do have to protect people from being surrounded by B&Bs. There's no great prospect of that happening at this point, but at some time in the future there may be, and if an individual owns a home in an R1 or an R2 district, I don't think you can allow that home to be surrounded by B&Bs. What Melissa Wynn brought up about the special use was that if it's left to the special use provision, you're going to have a political battle every time you have one of these. This battle over 300 Church Street was not pleasant. Nobody came out of it unscathed. And she was attempting to set a limit so that people knew when they bought homes whether or not they could have a B&B there. Thank you.
Let me ask one question. The text describes special events as special events, e.g. weddings. So I know that a wedding is a special event, but I don't know what else is a special event. What are you thinking about as special events?
In some other ordinance, it's events that are attended by those who are not staying in the house.
Okay, that gives us some idea.
I'm sorry, what is your name? David, I'm sorry. I've met you before. I apologize. You did have an interesting point that if you have an ordinance and you buy the house, then you should know that the ordinance was in existence, so you can't buy a house for B&B if there's one within 900 feet. What about the huge percentages of Evanstonians who've owned houses for many, many years? Would you recommend that they be grandfathered? Because one of the reasons that was brought up to do this is because this enables some empty nesters to stay in their houses longer, to help pay taxes, property taxes, which keep going up, and we want to encourage people to stay in their homes.
Let's focus on special events, because that's where we are.
I was cut off.
Well, your argument is conveyed to the commission,
okay.
And your question was in the nature of an argument. But let's finish this, and if you want, we can come back to distancing requirements if you aren't satisfied with the commission's decision.
No, the issue was, it dawned on me perhaps grandfathering, and then perhaps that will satisfy.
What are the views on the number of special events and whether we need a more clear definition?
One a month.
I agree, one a month, but I also think that we should have a better definition.
And other members?
Okay, Ken, help here. On the J, it says no special events may be held until an approval is actually sought from the city, right?
That's correct.
That's correct. And then when we go to permitted temporary use, it says basically you can hold 3.
Yes.
Okay. Now, we've been talking about bed and breakfast here, so the assumption is that somebody comes and stay here. It says not more than 4 weeks. Now, once it becomes something that you can hold regular, maybe monthly parties for people or whatever, it's something else. I mean, again, what I'm operating on here is this is, I think they say not more than 5 rooms could be occupied. A family has to be in there. When it becomes something where weddings are being held, and again, let's think about typical Evanston homes here. How many weddings are going to be held at these places? I think we are now, it's no longer a typical bed and breakfast anymore from where we're heading. It's becoming rental center. It's becoming a place where you rent to have events.
But by definition, a special event could be a luncheon for a couple celebrating an anniversary. It doesn't mean that, the home next to you, my home, if I converted it to a B&B and had 2 rooms, there's no way we'd be having weddings in that house. There's just no way. And but to suggest that you couldn't have a luncheon for the family that came in for the wedding, because you can only have 3 special events, I think that that's not right.
Okay, you can't have a luncheon for the family that came in for the event that was held at the bed and breakfast or came to Evanston for any event.
Any event.
Well, I mean, if you're in a bed and breakfast and somebody puts together a lunch for you, who's going to know that they're having a lunch somebody's having a luncheon for you?
But it's still a special event. It's by definition a special event. If people are coming in to attend an event and they are not staying in the B&B, the definition, that's a special event.
We don't have a definition yet for special events other than e.g. weddings.
There was no definition really discussed at the subcommittee level.
I'm not faulting you.
No, I understand. I'm not trying to defend myself, just to an explanation. And again, this is also one of the point. This is the one particular point where there was no consensus from the subcommittee. So it was meant to be brought to the full commission for a fuller discussion, including potentially defining those events. As far as where the language itself came from, and again, it's here as a placeholder. The J647J then ties into 6483, the permitted temporary use regulations. There's an existing temporary use regulation, which is 6843A2 rather than 7 here. 2 reads, in-home seminars or parties. In-home seminars are parties held for the sale of goods or services shall be allowed, provided no more than 3 such events shall be held within a 12-month period. Essentially, we're talking Tupperware parties and the like. So that was the model upon which I drew when providing this here. So the number to some extent is arbitrary, as far as in the draft. But if the commission wishes to regulate them, it may. And as to the number and in what time period, that's up to the commission.
I start to see this as something that's going to be very difficult to enforce. Maybe there's a distinction between in-house functions and outside functions that seems to be your concern that would affect your neighbors. I'm just throwing that out.
Barbara, did you have your hand up at one point?
No, not for this. Just, I think we need a definition, but we may need some discussion to determine what that definition is.
I'm not sure the inside and outside distinction is useful, because large weddings bring a lot of people to the area and affect the neighborhood even when they're outside. Large events. I do agree with Seth that restricting family from having what other families would have as family events is problematic. The language that you've used is essentially events designed to raise money for the owner, and that might be a useful distinction, though extremely difficult to enforce.
But doesn't a special event where you're coming in for a lunch and raise money for the owner?
Only if the owner is charging for the lunch or charging for the facilities.
But that's what a special event is, so that the owner of the B&B can actually earn additional revenue.
I don't see anything in the definition that would suggest that's what a special event is.
Question.
I'm just suggesting that maybe that's what should be in the definition.
Well, I mean, as long as we're talking hypotheticals, what if the owner, occupant, operator of the B&B has 4 children, each of whom is to be married, and each of whom wishes to have their wedding at home? It's not a commercial event, but it's an event.
That's the problem that Seth is raising, I think.
Exactly.
And
I think do we have to draw a distinction here between commercial and other events? Family events versus corporate events or something?
That's what I'm suggesting.
Oh, I think you should, but I still think you should have more than 3 corporate events. Non-family events. I think family events should be excluded from this.
I would agree.
Other members?
Well, first of all, it's going to be almost impossible to make a distinction between family events and events staged for guests. And I think Commissioner Ledesma brought that up quite a while ago when she actually said, what are the limitations that the city has on families? And there are none. Again, I read this very differently, and it says, I'll end it here. I think the easiest way to put this, at least for me, is to basically say, well, if you're a bed and breakfast and you want to hold a special event, you should seek approval from the city. So.
But the question then becomes, what's the standard for approval? And that's really what we're talking about.
Are you saying approval for something that's inside as well? So you have you're in town for a wedding at the Hilton. You happen to be staying at this lovely little quaint bed and breakfast, but the rest of the party is staying at the Hilton. But you want to have your in-laws and your parents over, and maybe your brother and sister, for a lunch. That's a special event. Do you have to get a permit for that?
No, I mean, my assumption is that, first of all, if you're staying in a place like that and you're having your in-laws or whatnot to come, the place can accommodate whatever luncheon or whatever event you want to have in that place. So I don't even see the owner actually going to the city to ask for permission. I don't see that. And I think we are basically pulling things out of everywhere just to make this more complicated than it is. And again, if we don't, maximum 5 rooms, bed and breakfast. Just how many people can we fit in this particular place? Not much. So I don't see, except if it's something loud outside the home.
So are you proposing to eliminate the special event requirement?
I'm saying that if you're an operator and you desire to do something that is going to spill over outside, then it makes sense to go to the city. To make sure that you follow whatever rules they have. But if it's having a small luncheon inside the house, I don't think any owner will go to the city and say, I'm having breakfast for 5 people. What do you think?
So you propose to define special events as outside events?
I'm not proposing that. What I'm saying, I'm part of the thinking here.
Okay. I'm trying to figure out, the distinction you made was outside, get permission, inside, no permission. So the way to do that is to define special events as outside events.
Well, in my mind, I mean, if you're doing something inside, I think it will be difficult for anybody to prove that you're able to prove that you're having lunch in there. So, I mean, I don't think that's an issue at all. You know, I don't think it will be an issue. However, if it spills out where cars are parked on the street, where people are in the backyard, and it's going all hours, it's a different story.
You can have an inside function with enough people that you have 30 cars you have to park, and
making
that's
a
a
lot of
concern.
noise where the police get called.
Well, those are
Happens all the time.
the ones you go to.
You had to spill the secrets. You had to spill the beans, huh?
How does the commission wish to proceed on this? I think maybe we need a definition before we can know what the number should apply to. Any suggestions? Yes.
Well, I think we've already talked about, and I would be in favor of making a distinction between a commercial event and a non-commercial event. I mean, if there is a charge for, as you said, I think products or services, does that include meals? We want to be sure that that includes meals. If there's a charge for it, then to my mind, it's a special event. Now, do we want to, and then I would go on to wonder, is it, if a special event requires that there be a certificate of zoning compliance, is that approval for the special event?
Certificate of zoning compliance, one applies to the zoning administrator, who then reviews the applicable regulations and can administratively issue such a document. In this case, this did come up at the subcommittee discussion, was that if they're for the example, 3 within a 12-month period, provided that the application is made and that there isn't anything amiss, essentially you get 3, without a great deal of consideration or concern. It's just that once you hit the 3 within the 12-month period, you are capped. So, but again, the regulation that I read before for the Tupperware parties, for lack of a better term, is that when it's a seminar or party held for the sale of goods or services. So that doesn't reach purely social gatherings.
Where there's a charge for the gathering.
By whom?
Oh.
And to whom, I guess, is the question.
Okay. Well, I guess I'm just suggesting, not that we.
No, I understand. I'm just trying to.
We take that definition wholesale, but that we distinguish between commercial events and a party. I mean, it seems to me that you would only want to regulate something that is done for profit. That would be my opinion. And whether the number is 1 per month with a maximum of 5 per year, I mean, we can quibble about numbers, although I personally would not want to see more than 1 per month. I also think that if we want to have a threshold that having, if there are guests who are having friends over and want a special lunch and there are fewer than a certain number of people, if we really want to make an exception for that, we could make an exception for that by saying a special event definition includes these commercial events that involve more than a certain number of outside guests. So you could have a de minimis, less than that number isn't considered a special event, doesn't require that a permit be issued. If we want to make an indoor-outdoor, I think that gets to be a little bit difficult in that so many inside events tend to spill out. So I'm not sure I would make that. I think the parking for a large number of people coming to an event really does impact. And so I guess I would make a cutoff over a certain number.
What number comes
of
to
guests outside. And I would say, well, anything over a dozen. I'm just throwing that out. It could be anything. But anything over a dozen starts to impact parking, starts to impact congestion. And I would think anything under that is unlikely to be that disruptive. or unlikely to need the kind of oversight that would be involved in getting a special permit.
I was with you all the way until you tried to set a limit on the number of people in an outside event. That strikes me as unenforceable.
Oh, I didn't say a limit on the number of people.
Well,
I'm
even
saying a de minimis. In other words, you have to get the way I see it is you would need to obtain this certificate if you had more than 12 people. I didn't say, and you couldn't have more than 50. I mean, I'm not suggesting that.
No, even the de minimis level strikes me as unenforceable. How are you gonna do that?
Well,
Somebody,
if someone's...
somebody says, "Oh, I've been invited to this event at your house, and my brother-in-law just came to town. Can I bring him?" And you have to say no because the zoning requirement is that I not go above this level.
But we're talking about only bed and breakfasts,
Well, yeah.
not the rest of the world.
No, I understand that.
What are the limitations on this on other homeowners?
Yeah.
What are the limitations on other homeowners in terms of special events?
To the best of my knowledge, essentially there aren't any.
Yeah, so-
unless one is, again,
So if you're
seeks
in
a
it-
loudspeaker permit or some such.
So anyone can have this kind of special events in charge in their house? Because
I'm
if
not
there is
aware of
not a
any
legal
regulations
limit,
that
why
reach to
should
that.
we? So if there is not a legal on a common homeowner, but if you have a bed and breakfast, then because you wanted to make money, then we're going to preclude you from making the money.
I think if you go into the restaurant business, it's not a residential use anymore. Even the catering business.
Isn't it precluded by the limitation by the cooking limitation?
Well, this is for bed and breakfast, but I think if you are regularly having people come and charging for it, that's not a residential use. It's not listed as a home occupation.
The B&B can only cook breakfast.
But they could have catered events.
Well, let's talk about commercial. You mentioned commercial. How is it different if you had a commercial event with 12 people show up, or you were having a wedding reception with 12 people show up? Same number of cars, same number of people, same noise level perhaps. And one's permitted and one isn't. I don't know if you can do that.
I'm not sure I understand.
Well, you said you wanted to have a permit for a commercial.
Where you're charging. You're charging people
Right.
to use your bed and breakfast.
If I'm charging people to use my house
Okay,
for events.
That's what I mean by
Okay,
commercial.
okay.
If there's a charge
if
for
there's
this
a
event,
charge to use the facility.
yeah,
to
then I would
gather
say that there should be some oversight on that. There should be some limitation on the number of those that can take place in any month and in any year. And if people are concerned, well, there are these small little things that happen, that's the only reason I threw out the de minimis.
No, we don't have a zoning police. Mostly, I think,
It's your neighbors.
the office relies on complaints.
I mean,
Because
if
then
the
the
bed
office
and
relies on
breakfast
complaints.
owner-operator wanted to have a wedding for their own children, that wouldn't be precluded because they're not, unless they're charging their own children to use the facility.
Okay.
This is something that you charge for that I think should be regulated.
Is it regulated for other homeowners? It is.
If
If
you
I could,
charge for an event at your home,
Dennis will address that.
yes, if for certain events, such as renting your house to a film company, there's a special permitting process, and there's a limit on that. Yard sales, there's a limit of 3 per year. I'm not conversant with all aspects of the code related to commercial uses of properties, but we obviously regulate that in residential districts. You have to be a permitted home occupation to have a commercial enterprise operating from a home. And certainly if we discovered someone renting out their home for weddings every third weekend, I think we'd take some action.
So my point here is when we chose this 50% limitation, it's under a behavioral assumption that these people are going to behave like normal homeowners. And so why do we have to throw in the extra structure? Because we don't believe that this behavioral assumption works. So why do we have this behavioral assumption?
Well, it specifies, we're specifying part of what the behavioral assumption is. I've never come across a bed and breakfast that has weddings, but apparently it's a problem in some places.
The example that was given by Mr. Reynolds was in the Historical Society, which is not a bed and breakfast. So.
Mr. Freeman, your light is on.
I just forgot to turn it off. For once, I don't have anything to say.
There are no lights on. Maybe we should take a 5-minute break.
I can use an apple.
We'll be in recess for a very short 5 minutes.
I inhaled a veggie burger before I ran over. Before, he was waiting in my driveway for me.
You can get pneumonia that way.
I was still chewing.
And we were addressing the questions of special events. Is there anyone on the, let me just do some polling and see where we are. Are there people on the commission who believe there should be no regulation of what could be described as special events?
I'm laissez-faire.
So we have all but one of the commissioners that think there should be regulation of special events. How many believe that the distinction for special events should be based on whether they are commercial events, in that the owners of the building receive compensation? 1, 2, 3, 4.
But not mutually exclusive. I have other issues as well.
4. And in terms of the definition, then we might include that. Is there anything else?
Number of people should also determine a special event.
And let me just ask, how many would agree with that the number of people should be included? 1, 2, 3, 4, 5. So if we were going to include the number of people, can I ask the members to express what they think is an appropriate number and say why, those of you who believe in it?
I liked the dozen. I think more than that, indoor or outdoor, it becomes having a significant number of them become an impact, a detrimental impact to a neighborhood, to a residential neighborhood.
Ask the others.
If I had a vote, I would say 5.
I think I would go higher if we think that a special event is something that a bed and breakfast ought to be able to offer, then I think I'd go up to 25.
Well, 25
as a cap on the number?
As a cap.
Oh,
yes.
We weren't talking about the cap.
Oh, you're talking about
what makes it a special event.
Oh, what makes it a special event? Okay, because I would have both a lower number and an upper number.
What's
Okay,
your lower number?
The lower number. Oh, I'll stick with 12.
Others?
I mean, I can live with 12, but I think 12 is a bit high, but I can live with it. It's still high.
Sure.
It's like pulling straws here. It seems to me that the size of the property of the B&B might also be involved. 10, 12 people on a very large backyard, if it's outside. doesn't seem like it would have the same impact as if it was on a 20 by 20, if it was held outside. It brings in the same number of cars, unless they pool in. I think you're trying to shoot for a number that may not make any sense at all. I guess that's where I'm at.
Greg?
Could you clarify, is that 12 additional from those that are residing at the B&B?
I think that's the...
I would say a total of 12. That includes, okay, are you saying the owners or the people who are the guests?
Well, that's...
In theory, if you had 4 guest rooms, 2 to a guest room, that's 8. So are you saying an additional 4 people for a total of 12 equals a special event, or 16?
I think the total number of 12, regardless who it is, signifies that it's a special event.
And is that what you were thinking?
Yes.
What were you thinking?
I'm still back where I think trying to set a number is, we're picking one out of the air here. I think the question of the size of the house, the number of rooms in the house, I wouldn't set a number.
How many would agree on a total of 12? 1, 2. How many, at this point, don't want numbers as part of the definition? 1, 2, 3, 4.
But with a caveat. Yeah, with a caveat that if you're doing anything that falls within the realm of a special event, that it should approach city.
Well, the reason for counting is some people want it in the definition of special event.
I have an idea to limit all the numbers of special events. Whoever wants to have a special event should witness all this discussion. That will preclude any application.
Tell me more about what you're thinking.
Well, I think it's going to be difficult to actually put a number on the number of people who can actually attend an event. At the same time, I also know that the bulk of the people, whoever is operating this bed and breakfast, will probably not seek any permit or any approval from the city. So enforcing it becomes almost impossible. And again, I go back to what you said earlier. The only way we will know something is taking place that shouldn't be taking place is if somebody called to complain. I think if I were an operator of such an institution, and if I didn't want anybody calling the city, then the onus should be on me to call the city to see if I can actually hold this event here. And again, let's go back to what Richard said. The space will have a lot of impact on what actually take place at this place. If it's a 2-flat, 20 by 150 lot, I don't see a lot of weddings or a lot of other things taking place. It's just going to be a place where you sleep to enjoy Evanston. That's it. I think maybe we should punt this one to have them go to city and make sure that whatever the number of people coming over there meets the legal zoning requirement.
Need to make a recommendation to the council about what the legal zoning requirement should be. They will do what they wish, what they believe to be correct, but given the draft and the action of the subcommittee, I think we need to say a recommendation.
But if you look at J basically says if you want to hold any special event, you should make sure that it's in compliance with City of Evanston zoning. That's an out right there.
But we have to decide what the City of Evanston zoning should be. At the moment, the only way we know the only thing we know for sure is that a wedding is a special event. And there's no exception for families.
But Chairman Peters, is there a way we can define special event as anything that anything that falls, anything outside the realm of actually sleeping in the place and eating that one breakfast that has been stated in here. So, for instance, if you want to have a special lunch with 12 people attending, so anything that goes beyond what a bed and breakfast is a special event.
We could do that, but Seth especially worried that the family occupants should be able to have regular family events.
Well, I mean, how do we...
Without being limited to 3.
And they shouldn't, because, I mean...
They shouldn't or they should?
The family, I mean, the occupiers of the place, the owners, we are not regulating them. We're regulating the people who live there.
Then the definition has to be changed. And that change was what Barb Puda sought to accomplish by distinguishing between commercial and non-commercial.
Right.
Yeah. Chairman?
Yeah.
I mean, are we, this will undoubtedly not pick up every possibility, but somebody mentioned earlier the reference here that only breakfast may be served. Are we really talking about cases in which meals are served other than at breakfast for which the guests in the bed and breakfast pay?
Or people who are not guests in the bed and breakfast pay?
Well, no. If you say...
I mean, by not guests, I meant the guests and other non-occupants.
Well, or food other than breakfast for which the owner, occupant, operator is paid.
I'm sorry?
That would work.
But you can have an event where food isn't served.
Would you really? I mean, yes, you could.
You could.
What are the odds?
Well, your Tupperware party.
Well,
Sure.
You might have chips in a bowl. That counts as food.
Well, can we go to Commissioner Puda's effort to separate, to make a separation between commercial, which regulates something that you charge money for, and the other part, which is basically staying away from the owners who actually live there.
Yeah.
So,
I mean, we're getting closer on that.
So I think
we're getting closer.
I think that's where we are. And the only, I think there's consensus that the majority has made that recommendation. And then some people want a number. So we're really only talking about whether there should be a number. Does anyone still want a number?
I'd be fine with between commercial and non-commercial.
Hearing nobody that wants a number, can you write a definition that distinguishes whether the events are for compensation?
I believe I can. I would ask for one point of clarification.
Please.
Would it be a special event if the only attendees were B&B guests, or does it require that persons other than guests of the B&B, as in people staying overnight, also attend? Is that a threshold issue?
I think that's a good point.
Because under the circumstances in the B&B, suppose you have a very large B&B, 5 guest rooms that can accommodate 2 people per guest room. So potentially breakfast could have, 10 B&B guests plus the owner-operator occupants, however many of them there are. But if none of the attendees if none of the attendees are non-residents or guests, does that preclude it from being a special event? Does it require the presence of non-guests, non-residents to become a special event?
I think the tie was other than breakfast.
Be that as it may.
Okay,
For whatever
wine
purpose.
and cheese in the evening. A bed and breakfast often puts out some fruit, some cheese, some wine.
If there's a charge for wine and cheese separate from the fee for staying there.
So no, the issue here is non-residents. So if you're not, even if you're not charging, if you have non-residents coming in eating wine and cheese, is that a special event?
I think it is under what we've talked about.
So the point Ken had was, if it was non-residents, it becomes a special event, right? That's what you were trying to make the definition, or the distinction.
If it's
I think
non-residents, then there's a charge, yes.
Well, what happens if there is no charge and there's non-resident?
And it's not commercial.
Okay.
Now that we have some consensus or some decisions on special events, we can move to cooking facilities.
Based on our conversation and what the consensus we just came to, I think I will withdraw my objections on the definition that we have here on the cooking facilities.
Does anyone else wish to change the definition of cooking facilities from the text, draft text?
I have two questions, if I may.
Yes, please.
Question one, no additional cooking facilities may be installed after application for a special use permit. I don't know what we mean by cooking facilities, but if I was going to go into the bed and breakfast business, I might not upgrade my kitchen until I knew I was going to get the permit.
The conversation that happened at the subcommittee meeting was additional kitchens. So if you have a primary kitchen and you want to upgrade it, that's still the existing kitchen.
Okay. Now I will go in way over my depth. I know there are families who keep two kitchens because they keep kosher.
That's correct.
This would seem to preclude that.
Can you write something that rewrite this to be additional kitchens and put in an exception for second kitchens required for religious purposes, or bona fide religious purposes?
I believe so. But just as a practical question, if the homeowner for religious purposes has a second kitchen, would presumably or arguably one would go about installing that
already?
Yes, prior to becoming a B&B.
Okay.
Although certainly there are opportunities and reasons why one may not later. Maybe perhaps one becomes more observant at a later date and decides to install the kitchen, after owning the home for decades and possibly operating the B&B for some time.
That's why we have a ZBA. Because somebody could come in later and ask for variance. Yes?
I'm not
sure
that it would be covered by the variance.
The variations are actually they're a closed universe. They're a defined set of types of variations that are available under the zoning ordinance, and that would require an entirely new type of variation.
Seth, while they're conferring, did you want to say something about kitchens?
In-law kitchens that already exist are okay, right? We talked about that. An in-law kitchen, right? You have an in-law apartment in the basement. We had a conversation at the subcommittee about that we shouldn't be excluding something that exists, correct?
Correct. The intent of the language written is no additional cooking facilities. So if you have two kitchens already installed, you cannot add a third after you apply for your special.
But if you had two, that doesn't say you can still have a B&B. You won't be excluded from having a B&B or be told you have to get rid of one of your kitchens.
Correct, based on this wording that Ken's prepared, but the existing kitchens would have to be legally established kitchens. A big concern we have in the city, and it's more than a concern, it's a problem we have where second kitchens can and do lead to sometimes having illegal dwelling units. And so that's partly what's driving this issue.
I think we probably, with a footnote for the religious exception, it's covered. Is there anything else that we need to do with cooking limitations?
I've got a question. And again, Ken, maybe you guys can help, and Craig, when somebody applies for a permit to actually open a bread and breakfast, I assume you guys will ask whether their existing kitchen is adequate to support the maximum 5 people. That is, if that house can potentially house 5 rooms, right?
Let me expand the question.
Please.
Is the approval of bed and breakfasts tied to health requirements for cooking?
There are, I believe, 21 parts of the health requirements for B&B establishments. I'm trying to pull them up right now, but for whatever reason, Muni Code is not allowing me access to them. But I know that cooking facilities are one of the things that they are
so
most.
we don't have to put that in this ordinance.
Yes.
Thank you.
I also have a question. If you own a house in Evanston and you have 2 kitchens, you cannot put a 3rd one? For whatever reasons. I mean, you are obsessed with cooking. Who knows?
Certainly, I think the experience we have is single-family homes. Generally, there's 1 kitchen. There's some exceptions to that. I don't think I've encountered a request for a 3rd kitchen. We would be highly suspicious of that if that came along.
So my point is that why are we, if we don't have special regulations for other households, why are we hampering a specific kind of owner of a house?
We do have special regulations for other households.
They should be subject to the same. Save some additional, more stringent requirements for health code.
But other uses don't have guests, paying guests.
There should be material. I mean,
Well, the question is whether the
code
paying
allows you to have 3 kitchens, you should allow it to be.
The question is whether the paying guests are getting kitchen suites. And that's really what this is.
Again, the concern on the part of staff would be in a very large home, adding additional kitchens would create the potential for carving up the dwelling into other rental units, illegal rental units. If you look at the legislative history for the establishment of bed and breakfasts as a special use in the zoning ordinance back in 1973, one of the biggest concerns was them turning into rooming houses.
But if I intend to have illegal renting units, I'm not going to ask for permission to put the kitchen.
We certainly would. We do seek folks out, rental units that are illegal.
They find them.
Yeah, but
Neighbors report it.
Yeah, but they won't apply for a permit.
No, but this isn't about applying, it's about operations, as well as applying. Are there any other provisions in this draft that the members wish to address?
Parking.
Can you tell us your concern about parking, please?
Ken, would you take this? It's section F there, and I thought that Dave Galloway specified 1 on-site parking.
If you look at the next 2 pages, actually, 616.12 and 616.35 have to do with parking. 616.12, generally a change in use for a given structure does not require a change in parking, except for, and there are exceptions. The current ones are for medical or dental offices or change in religious institution in certain districts. The proposed language here in 616.12C indicates a change in use to B&B establishment in any district. And then that leads us to 616.35, which states that, so essentially what that means is if you become a B&B, you have to comply with the parking requirements, regardless of whether or not, regardless of whether or not you were constructing a B&B, but actually the zoning ordinance already says you cannot construct a structure specifically for the purpose of operating a B&B. So, but it ensures that the change in use is covered by the parking requirements in 616.35, which in the proposed text do require one space per guest room plus one space for the owner-operator occupants.
But my reading of Table B in Section 616 says that for purposes of satisfying this requirement of one space per guest room, on-street parking,
Where does it say that?
along the curb.
That's struck through.
Pardon?
That part of 616.35 is struck through in the proposed text. The B&B establishment language in 616.35, 16B reads, if it were to be approved as drafted, one space per guest room plus one space for the owner-operator occupants, period.
Okay.
And everything thereafter is
But the
to be deleted.
existing
Yes.
requirement is that on-street parking may be considered.
Yes. And
That's the existing one.
that's correct. And that was
Okay.
the subject of much discussion.
Okay.
And
Now,
hence the change.
how do we square that with the requirement for a rooming house, for example, that requires, I think it's one on-site parking space per four persons? I mean, what's the rationale for distinguishing between those two? It seems to me that we have to if we're going to modify one, I think we should modify the other.
I think the rationale is that for guests coming to a B&B, they are extremely likely to come by car. And people in rooming houses, only some of them typically would have a car, and many people in rooming houses would rely on public transit.
Okay.
But in the B&Bs, they'd all have cars.
I would concur with Chairman
Okay.
Peters. One of the licensed rooming houses in the city, or rooming establishments in the city, is the Y. And one certainly would think that not every resident thereof has their own car. Whereas folks who are guests at a B&B, given the fact that they're staying at a B&B, likely are coming from out of town in some fashion, and will then be, coming from the train, from the airport or some such via a rental car.
So if we have a big house and we want 3 guest rooms, for example, we would have to have either a 4-car garage or some sort of on-site parking.
That's correct.
That's pretty onerous, is it not?
It's
And I'll tell you what
stringent.
I'm thinking of. There are a lot of places on Orrington Avenue, for example, on the north end, where parking is sparse, and where people don't have 3- and 4-car garages. I think it would be almost impossible for them to operate a bed and breakfast under those circumstances, unless they could park on the street, or at least some portion.
The discussion,
Street.
the brief discussion before about variations, parking is a permitted variation under the zoning ordinance. One could potentially, if you had, in your case, if you had 3 guest rooms, but only had 3 on-site parking spaces, you would be deficient by 1. One could apply for a special use permit for a B&B establishment and a related parking variation, both of which would end up before the full city council for deliberation simultaneously as part of one application.
But if on-street parking were allowed, for example, and the city council or the zoning board of appeals decided that it interfered with traffic and interfered with the parking circulation or whatever, they could refuse it for that reason, could they not? In other words, it gets back to this special use thing. And now, well, I guess I've said enough on this subject. I think it makes it very difficult to even consider. Craig, you want to say something?
Yeah, sorry. This goes back to the conversation originally on number of rooms that are allowed to rent, and forgive me if I'm incorrect, but the conversation led to tying off-street parking requirements to capacity of an actual B&B. And so removing the allotment for on-street parking would help regulate how many rooms one may be able to apply for a B&B. Do you remember that?
Yes.
And that's where we arrived to this decision was, or where you arrived to this decision was tying it to off-street parking requirements per guest room, as other communities have done.
But it does make it very difficult. I mean, I think we as a community have decided, I didn't decide this, but somebody years ago decided, a council decided, that we wanted B&Bs in this community. Many communities around here don't allow them. Wilmette doesn't, Winnetka doesn't, Kenilworth doesn't, Glencoe doesn't. But we have decided that we will allow them. That being the case, why do we make it so difficult for people to operate a bed and breakfast here if we put all of these very onerous restrictions on them?
Mr. Ford?
I wonder if we couldn't keep the limit that, as it is established here, one parking space per guest room plus one for the owner, operator, occupant, but allow two of those to be on street, which would mean that if you had only a two-room bed and breakfast, you would have one parking space on site and two off. If you had 5 rooms, you would have 2 off. You would still need 4 on, so that you give a little bit of relief, but not flood the neighborhood with on-street parking.
I would speak against it, against the change, as someone living in a neighborhood where I may well have a 2-block walk tonight. I mean, even as it is written, there are likely to be more than one car for the occupants. And so we have, with these requirements, increased the number of cars on the streets in comparison to not having a bed and breakfast. In other parts of the city where there is not a shortage of parking, variances are possible, but I would hate to see more cars. When the city came through and changed the radius of the corners, eliminating 4 parking spaces, it made a serious difference. And I'd hate to lose parking where I live and where I lived in my prior location in Evanston. But in other places, it's not a problem.
I think there was also a discussion of the owner-operator being able to rent garage space on the same block or in the same area where somebody isn't using their garage, or the city, an appropriate space out of one of the city garages.
How many of the board wish to change the parking requirements?
From what's in the draft?
From what's in the draft? One, the record should show. Two. Are there any other areas that we need to discuss tonight? Craig, when is the next meeting where we could look at the next draft?
That would be at the next regular Plan Commission meeting, which is currently scheduled for March 14th.
Would that be acceptable to the members?
Yes.
14th, our next regular meeting.
Yeah, next week's meeting is just the zoning committee of the Plan Commission, so.
We will be very sad when any member misses. Are there any committee reports?
We formally continue to the...
Yeah. This is a hearing on the proposed bed and breakfast zoning change, and it is continued to March 14th. For further discussion,
Mr. Reynolds wants to say something.
Mr. Reynolds?
May I bring up a point that I think you missed? You may not want
Yes.
to discuss it now, but under Section B, I believe the subcommittee limited it to 5 bedrooms with the owner of the property occupying one of the bedrooms.
No, if you had 5, no, we said 5 bedrooms could be provided for registered guests. That means you'd have to have a 6th bedroom.
Right. But the intent, I think, was that the owner had to occupy a bedroom and not live in the basement.
Well, let me ask the commission if they
No,
wish to.
that wasn't the intent, because in our...
Regardless of what the intent was of the committee, we can just ask the commission how they wish to proceed on this. Go ahead. Ms. Puda?
If the intent is, if the intent is, and I would favor it being the intent, that the occupant actually occupy a bedroom, then I think we should be specific about it.
This says a maximum of 5 bedrooms may be provided for registered guests.
Right. Is there another place where it says that an occupier means someone who uses the additional bedroom?
Do you want to add a sentence to?
A says it. An owner-occupied single family.
But the
Well, it
question,
doesn't say whether he's in the basement or
We had this
the cellar.
So in the conversation we had in the subcommittee meeting, I have 2 friends that have families, and they all live in the basement. There's 2 bedrooms in the basement, and the grandmother lives on the 1st floor.
It is a bedroom, though.
That's correct, but you just said in the basement.
Well, I
okay,
was
so
referring to-
a basement can have a bedroom, an illegal bedroom.
Which is fine.
Okay.
I'm not opposed
Do
to
you
which
wish to
level
add-
the bedroom is on.
Okay.
do you propose to add a sentence that says
I think we could clear it
a
up.
minimum of 1 additional bedroom shall be provided for the owner occupant?
You could add it there, or you could add it to the definition of what an owner-operator occupant is.
Probably.
So they can't sleep on the couch is what you're saying.
They must sleep in a bedroom.
Probably it should go in B.
Why are we regulating these things?
Why?
Well,
They have to-
what
they
is
have
an
to live in the
occupant? What
premises.
is an occupant? Is an occupant just someone who shows up during the day?
No.
I think it's
I
a
think-
good question.
Absolutely.
How many of, let me ask, how many members of the commission would like to add a sentence that says a minimum of 1 additional bedroom shall be used by the owner occupant? Or something to that effect?
Something to that effect. I don't think we have to send out the police to monitor if it's actually being used, but it be available or provided for.
Isn't it enough that the owner lives in the premises?
I don't think the owner lives in the premises if there's not a bedroom, a designated
I
bedroom.
mean, according to whose standards? I mean, I think it's most people will fall naturally in the bedroom situation, but if you have, I mean, we are over-regulating here.
I don't think we are. I
don't
think
think
it's
so
ripe
either.
for abuse if we don't provide that at least one of the bedrooms is provided for the occupant and not for guests.
I think we'll get owner occupants who are non-occupants.
I think so too.
You can still get that if you have to have one of the bedrooms.
That's right. But
So-
you can also limit the amount of space that's used for guests.
We are by saying a maximum of 5.
No, we're not.
Yeah,
It's
we
a
say-
maximum of 5 guests, and we're not saying anything.
5
of-
bedrooms.
No.
Maximum of 5 bedrooms.
For guests.
Right.
Yeah.
And we're not saying anything about whether there should be an additional bedroom for the owner occupant.
All I was saying is if you're worried about somebody not spending the night with requiring a bedroom for an owner, they could still not spend the night. That's all I was saying.
but
The,
if-
the, the,
but-
What
the
it does
existence of a
prevent-
bedroom,
But if there is no place for the owner,
But it makes it,
it's much more likely that they won't be there.
yeah, that's true.
But they're required to be there.
yeah, it says that, right?
But,
They're owner
but if there is
occupied.
no bedroom, I think it becomes much more likely that they're not there.
I don't think
I
so.
think we're giving very little credit to the owner here.
Yep.
I would agree with that, but it might be right.
I have another friend who sleeps on the couch. And it's because his wife wants him on the couch.
As a practical matter, if one were to submit an application for a special use for a B&B establishment in a house with 5 bedrooms, and in that application, one indicated that all 5 bedrooms were to be guest rooms,
Red flag.
I would imagine that the zoning administrator's first question would be, where are you going to stay, Mr. or Ms. Owner, Operator, Occupant? And I believe that would present a significant hurdle for the application before it even went to ZBA and
Wouldn't
council.
it be nice to have that in the text so that the staff is protected from someone who doesn't want a bedroom and doesn't really plan to live there?
But that then brings us back to the fact that the owner operator is required to occupy the property.
And 2 years later, they have all the bedrooms filled with guests, and they claim to be staying in the unfinished basement. And you go to court, and they say, that's perfectly permissible under the ordinance. We can stay on the stairs.
I
The
think
basement.
I think the other thing that it would achieve by saying there has to be at least one set aside that's not used for guests, one set aside bedroom that's not used for guests, is that it prevents overuse of homes for guest purposes. So you wouldn't ask
Why
for
that?
5. If you only had 5 bedrooms, you couldn't be asking for 5 guest rooms. You could only be asking for 4 guest rooms. If you only had 4 bedrooms, you could only be asking for 3. It's not overloading a house with guests, and I
it's-
think that's important.
Yeah, it's like going out for Chinese food. You always order N-1 number of dishes. Yeah, so I would agree with that. I'll support that.
Mr. Ford, I
It strikes me as equally plausible that this owner-occupant operator who has 5 bedrooms and applies for space for 4 could have the 5th one occupied by a guest. That illegal move strikes me as just as likely, maybe more likely, than that the owner-occupant operator would end up sleeping in the unfinished basement. I think I hate to say this, but we are
Science
talking
project.
about Evanston here. And I think we're giving our people less credit than they deserve.
Let me ask how many people agree with Barb that we should adjust this to provide a bedroom for someone other than a guest? 1, 2, 3, no? And how many are opposed? 1, 2, 3. I vote to have a required bedroom. So that you can make that report to the council when we get another draft, and assuming that we don't make new discussion of everything we've decided tonight and changes. Is there anything else that anyone sees that we need to consider? Seeing nothing else, hearing of nothing else, this hearing is continued to March 14th, where it may not be the first item on the agenda, but we do have a night. Are there any committee reports? Seeing no committee reports, is there a motion to adjourn?
Second.
All those in favor?
Aye.
We are adjourned.
We had a good meeting today. We had a very